This is the case of People of the State of Michigan versus Police Brewer. 24S 31067. He appears in person in the courtroom with his attorney, Ms. Reed. This is set for sentencing, I think.
All right, Ms. Reed, what do we do?
There's not a breakdown in the attorney-client relationship, and my client understands that if he no longer wants me to represent him, I've been his third attorney, and he would be waiving his right to court-appointed counsel. Ask the court to inquire Mr. Brewer.
All right, so Mr. Brewer, what's your position here? Ms. Reed is indicating to the court that sounds like your conversations have not been productive from the standpoint you can't get on the same page sort of thing. Where are you at with all of this?
Well, I mean, it's really not getting on the same page. She don't want to work with, for me, so there's no need. I'll represent myself. She don't want to file nothing that I'm asking her to file. So
right, but sometimes, not sometimes, when you have court-appointed attorney, their best legal advice, which often is to your benefit. So it sounds like, at least to me, if she's your third attorney, that you're not listening to anybody, that you have all the answers, which may be contrary to what's best for you. So she has a point, and one the court has to ask you about it. If the court were inclined to allow Ms. Reed to withdraw or grant your request to have you represent yourself, you're not going to get a new court-appointed attorney. If we've been through 3 of them, sounds like Mr. Nave, who runs the public defender's office, is saying we've done everything we can. You'll be forfeiting your right to have an attorney. So do you recognize that if the court is going to either grant your request or Ms. Reed's request, that you won't have an attorney going forward? Do you understand that?
well, I guess.
Well, it's not I guess. That's what will happen, right? If you can't get along with any of your attorneys, then you end up forfeiting your right to have an attorney unless you're going to hire your own. And then that leads to this whole series of next questions the court has to ask you.
Honestly, if you think about it, attorneys have a crappy job. Like, there's nothing worse than someone claiming they know your job better than you do when you spent years and years and years in studying this. And I mean, no lawyer is going to just refuse to file things for you. It's just so funny when you have defendants, she won't do nothing I ask. Well, it's probably because it would be pointless. It's to save, time, money, and attorneys know how to file things. Attorneys know, like, the ins and outs. So I wouldn't be able to handle, like, all these hard-headed defendants claiming they know my job better than me, right? So, yeah, I never thought of that before. Like, attorneys really have a difficult job.
If you are going on your own, in other words, representing yourself, you're at a huge disadvantage. One, because of the obvious. You're incarcerated in the Department of Corrections. So following the court rules, like getting things filed, discovery, all that kind of stuff is...
Clearly, it's obvious that he's at a huge disadvantage, okay? Not only is he not an attorney, but he's in custody, so he can't file or research things or anything like that. But not only that, like, his charges alone and what he's looking at is enough for me, if I were him, to be like, all right, I'll put my pride aside and stop being an arrogant a-hole and listen to my attorney. Because just wait, you guys will be like, what the hell is he doing? Like, makes no sense why someone would play Russian roulette with their life like this. Just wait.
Infinitely more difficult because of your current status, right? Number 2, and the obvious one is, you just are at a disadvantage because the other side has attorneys, experienced attorneys that know what they're doing. And even if you're the brightest guy in the world, if you're not an attorney and experienced with criminal law, you're just at a disadvantage. And that's That's just the bottom line. Do you understand all that?
Is another disadvantage is that you racist, Your Honor?
I'm racist? How am I racist?
I don't know. That's just what my lawyer told me. So I just wanted to ask you that personally.
Ms. Reed thinks that I'm
If
racist?
she said that you're a racist, but you're just gonna throw me away. So I just want to ask you that.
Am I racist?
Would that be
I don't think I'm
disadvantage?
racist, sir.
Well, that's a touchy subject. Now, none of us were there, so we don't know what his attorney said and what she didn't say. But I question it, right? Like, I don't think an attorney would say that to their client. But, yeah, it's a little... I think the judge has been really nice to him the entire time, you know? I really don't think that the judge is racist at all, but.
I think if we look at all the sentencings I do across the board, they're pretty consistent, regardless of race, color, creed, whatever the case may be. They're very consistent. I'm 100% comfortable and confident in that. So let's get back to the task at hand. Do you understand that if I grant this request for Ms. Reed or for you, you're probably going alone? Do you understand that? Do you understand that?
Yes, Your Honor.
All right. Is that what you want to do?
Yeah, I mean, ain't nobody gonna work for me, so I gotta work for myself, Your Honor.
Okay. So, well, we've had 3 different attorneys that have attempted to work with you.
He's lucky that the judge even let him go through 3 different attorneys. I mean, usually, from what I've seen, a lot of judges aren't going to sit there and play your game and go through all these attorneys to delay the process or you being hard-headed or whatever the case may be. I mean, he's lucky that he's been given 3 already, because a lot of judges would have been like, tough luck. That's your lawyer. You deal with it or hire your own. So, 3 different attorneys, and he wants to fire the 3rd one and move to a 4th or move on to himself, right? It's a you problem. It's a him problem. He's the issue, obviously, clearly. It's not the attorneys.
You acknowledge that, correct?
Yes, Your Honor.
All right. So now there's a series of questions I have to ask you. It's all connected to what we've been talking about. This, sir, this charge that you're facing is 3 counts of assault and prison employee. Those are 5-year felonies and/or $2,500 fine. You're also charged as habitual offender 4, which means all of them can be up to life. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that because they're up to life offenses, if you're representing yourself, again, you're at a disadvantage. Do you understand that?
Yes, Your Honor.
Okay. We're recording this, so you do have to answer. And so again, not meaning to insult you, but these are some required questions the court has to inquire on. We've touched on it briefly. The other side is represented by attorneys, experienced attorneys. So I have to inquire about you. What's the highest degree of education you have? Are you a college graduate? Are you a high school graduate? Are you neither? What is it?
GED.
GED. Okay. So again, required. You understand that with your more limited education, GED, you'll be up against folks that are experienced attorneys, and that will put you at a disadvantage. Do you understand that?
Yes.
Okay. You also understand that when you represent yourself, the court has to treat you in the very same manner that I treat Ms. Krause, Ms. Reed, or anybody else here. Meaning, because you represent yourself, you don't, and the court cannot give you some leeway as it relates to court rules, filing dates, even arguments about the law. Do you understand that?
Yes.
All right. In knowing all of this that we have discussed, you still wish to represent yourself?
Yes.
Okay. So I do have a motion before the court. Now, this was, it looks like it was filed July 25th. So I don't know how it came out today. That was.
But it's been pending. You know, we're here for sentencing. You pled guilty.
Right. No, I recognize that.
Okay.
Yeah. But the motion is something the court's going to have to.
Yeah,
entertain.
no, we got that July 25th, 2024. He filed that on his own when he had other lawyers, but he did file that.
So.
Am I, Your Honor?
What?
Am I excused at this point, or has the court ruled on whether or not?
No, I haven't even got that far yet.
All right, thank you.
I was trying to make sure that we covered all the questions we need to, that Mr. Brewer makes us a informed decision about wanting to go alone. All right, so back to the motion. Mr. Brewer, you have filed a motion previously about wanting to join the plea. So as it relates to that motion, if the court were to grant the request that you represent yourself, then the court would be considering your motion, again, without the benefit of having an attorney, and that would then in turn raise all those disadvantages that you would be facing that we've just discussed. Do you understand that?
Yeah,
And is that what you want to do this morning?
yeah.
All right. So I will allow Ms. Reed to withdraw. I want you to prepare an order indicating the court has granted the motion to have Mr. Brewer represent himself and that you are allowed to withdraw. And then the court will sign the same. And then, Mr. Brewer, are you prepared to argue your motion today to withdraw your plea?
No, Your Honor.
Okay, you wish to have some time?
Yes, 30 days, please.
30 days?
Yeah, that's possible.
Okay, one more thing then that I want to talk about with you. I can't remember if we've talked about this or not. So maybe we have. You know that Ms. Kraus is not going to be the prosecuting attorney here at the end of the year. There'll be a new prosecuting attorney. But what that means for you, if your case is not completed, and more importantly, if the court were to grant your motion, now I don't know what the court's going to do. I want to hear from you. I want to hear from them. But if I did grant your motion and allowed you to withdraw your plea, the new prosecutor then could say, I'm not offering you anything. I'm not going to do anything. You can have a trial. And then if you have a trial, again, recognizing we've just discussed, you'd be at a serious disadvantage representing yourself. You're facing up to life offenses for 3 of these counts of assault of a prison employee.
Yeah.
Okay, and that's still something that you want to do.
Yes, Your Honor.
Okay. Then why don't we go out 30 days? What would our date be?
December 5th.
December 5th. We'll come back and we'll argue your motion. So Mr. Brewer, in the interim, as it relates to the motion, if there's any filings you want to make, you can do that. Just make sure you have to send them to the other side and the court.
Just make sure he understands he's sitting on, this is dead time in terms of, let's go over that.
Well,
Make
we-
sure it's-
we can. I don't know.
he's informed of what he's just.
I don't know if that's even required, but we'll do it. So Ms. Cross is raising a point here that while this is pending, because of your status as an inmate with the Department of Corrections, you're not earning any credit for the time you're serving. Do you understand that?
It's already understood, Your Honor.
All right. And so again, if let's say we go out to, let's say your motion were granted a month from now, and then you don't get a trial date until March of 2025.
Time don't count. You got it.
Exactly. Do you understand? Does that change anything for you?
No, Your Honor.
Okay.
And
All right.
you're aware of the recommended sentence at this point, correct? The 10 months to 2.5 years.
No, tell me, what is it?
10 months
10
to
months.
2.5 years.
Oh.
That was the recommended sentence, the agreed upon sentence that we made at the
Right.
time of your plea.
So that maybe we haven't talked about that either in the past, but it was the court's intent to follow that. All right. So if you wanted to take advantage of that, and you can do that on your own too, represent yourself, you'd be sentenced to 10 months with the Michigan Department of Corrections to statutory max of 2.5 years. Now that's required to be run consecutive by statute. So it'd be consecutive any term you're currently serving. And that would be contrary if you had a trial and it didn't go your way and you're charged with habitual fourth. Now the minimum sentence would be
Life.
effective. No, that's the max. I'm talking about the minimum could be up to life, and the maximum would be up to life, but the minimum also would be much greater than 10 months. I don't have what those guidelines are in front of me. Do you have any idea? Just roughly
5 to 17.
5 to 17 is the
Oh,
minimum.
not with the HOA.
No, it'd be, I think it was like 19 to 47, I think.
All right.
Yeah, they'd be up there.
All right. So
Yeah, 19 to 76.
okay, so that's kind of everybody's best guess, not having run them. But what that means for you is it could be 19 months as a minimum sentence, up to 47 months, whatever it might be, and then life instead of 10 and a half to 2 years. Do you understand that?
Well, sir.
All right, and then knowing that, you still wish to proceed with a motion in 30 days to withdraw. Okay, then I'll see you in 30 days. Let's make that
12/5.
12/5 at 8 a.m. And here's a little housekeeping matter, one of the things that's gonna be tough for you. So I'm gonna need a writ. Generally, that's the defendant's responsibility. In this case, I'm just gonna ask the prosecutor's office to do that, so we make sure we have you here. But going forward, I can't promise you that, right? That's
I'll
again,
still file one myself too, Your Honor.
well, all right, one of the disadvantages. All right, so we'll see you on December 5th.
Just to make sure, 19 to 38 was without the HOA, so it's probably 19 to 50 something with the HOA.
Yeah, all right, which that means your minimum sentence, if things are, it could be like 5 years potentially to life. And it'd have to be served consecutive, whatever you're doing, as opposed to the 10 months to 2.5 years that you could get now. If you put that in perspective, the max on the sentence you could have today is less than the minimum on what could happen. So again, you still want to proceed with a motion to withdraw? That yes?
Yeah, I said it 3 times already.
Well, I know, but we're recording and so we're making a record. We're making a record. All right, you're all set. I'll see you in 30 days.